Well, hello, everyone. Thank you all for joining us for this evening's program on wills and powers of attorney. My name is Dylan Ryder, and I work with the Johnson County Library's Career and Finance Committee. Tonight, we have the privilege to be joined by Alex English from Kansas Legal Services. For some more information about our presenter, Alex is the managing attorney for Kansas Legal Services and the statewide director of the Kansas Legal Services Elder Rights Project. In 2020, Kansas Governor Laura Kelly appointed Alex to be a member of the Board of Adult Care Home Administrators. Alex has found that her days spent working with her senior citizen clients are her most enjoyable ones. She feels a connection to this group of clients and finds it rewarding to work with them. Alex has been with Kansas Legal Services for almost 14 years. In addition to handling cases for senior citizens, Alex also regularly handles bankruptcies, protection from abuse, and protection from stalking cases, divorces, and paternity cases. Alex is licensed to practice law in both Kansas and Missouri. Alex earned her law degree from the University of Kansas School of Law, Rock Chalk, and her undergraduate degree from Kansas State University. Well, feel free to participate in the program's discussion by using the chat to add your comments and questions at any point during the program. Alex will attempt to address your questions as time allows following her presentation. FYI, the contents of this program will be recorded for future viewing. You can find those recorded programs at youtube.com/Joco Library. Thank you all once again. Here's Alex.
Thank you, everybody. I'm not sure that I've ever given a presentation to so many people at one time, so thank you for joining me. As I said earlier, this is not my favorite format. I far prefer to be in person and to interact with the crowd, so it is a little intimidating to know that you're all sitting there staring at me and I can't really interact with you. So hopefully this will go okay. Also, just a full disclaimer, everything that I say today, I'm a lawyer, nothing is legal advice. I'm not directly talking to you about your individual situations. So none of this is legal advice pertaining to you as an individual person. And if you do have questions, we recommend you talk to an attorney. Okay, so tonight I'm going to talk about estate planning and then also some powers of attorney and other legal documents that might be helpful for you or for your relatives. So the very first document that I'm going to talk about, if I can get my screen to change here, it's a power of attorney. And this is a pretty important one. A power of attorney is a document in which the principal gives authority to an attorney in fact to make decisions and act on the principal's behalf. That's a lot of legalese, a lot of legal language there that might be a little bit confusing. So let's break it down. Principal. A principal is the person who signs the document. So if it's your power of attorney that you've signed to give someone else the ability to make decisions for you, you are the principal. The attorney, in fact, is not actually an attorney at all. I have some of my clients who fill out our forms and they say, oh, you'll be my attorney, in fact, because you're my attorney. No, it's not quite the same thing. It's just a fancy way of saying agent. So it's someone that you've chosen to designate to do things for you, to make decisions for you. So that's kind of the pertinent language. Powers of attorney, as we've gone through COVID, and I think that it's important to be thinking about if something happened to me, if I were in a coma or if I were unable to make my own decisions, who would I want to be able to do that? So that's what this document is for. It designates someone while you're alive. There are different kinds of powers of attorney. The first kind I want to talk about is a durable power of attorney. Then the alternate to that is a non-durable power of attorney. A durable power of attorney stays in place even after you become incapacitated. And that's kind of the whole point of it as we think of it. You become incapacitated and you want somebody to make your decisions. In that case, you're looking for a durable power of attorney. An example of a non-durable power of attorney would be if you had a power of attorney for a very limited period of time, so for a very specific purpose. If you were going to be out of the country when your house was selling and you wanted to name your sister as your agent to act on your behalf through that sale and sign for you on the sale of your house, that power of attorney might be for a very short period of time with an end date. And that would not be a durable power of attorney. But as we talk tonight, we're talking as a durable power of attorney that's ongoing after you become incapacitated. Two other kinds of powers of attorney. There are powers of attorney that are springing or that are effective now. A springing power of attorney is one that only springs into effect upon incapacity. So there's a statement in the power of attorney document that says that this is only effective upon my incapacity, and then 2 doctors would have to make a finding that you are incapacitated. And then that power of attorney springs into effect. Even though you have it drafted before you're incapacitated, nobody can act on your behalf until those doctors say that you can't make your own decisions anymore. The other kind of power of attorney is effective now, and that's effective right as of the date of signing. So if you go to your attorney's office and you sign all of these documents and it's effective now, once you leave the attorney's office, whoever you've named as your agent technically could act on your behalf. There are pros and cons to both of these, and you really have to weigh them. What I think is that if you really trust the person that you're choosing, that it's probably better to have it be effective now, because some people do get slow progressing diseases like Alzheimer's or dementia. And when those diseases come in, one day you could be okay, the next day you might not be, the day after that you might be okay. So it might be kind of difficult to get that doctor's statement saying that you're incapacitated. So for that reason, it's preferable for me, at least, to say that an effective now power of attorney would be better. However, I have some clients who really don't trust anyone else, and they have a really hard time doing what they see as giving up control, and they won't sign one unless it's springing. And if that's all that you'll sign, then absolutely have a springing power of attorney. It's better than not having one at all. In my opinion, everybody over the age of 18 years old should have a power of attorney document, because you never know what can happen. Okay, the next two different kinds of powers of attorney: healthcare versus financial. So the healthcare power of attorney, if one kind is healthcare and all it handles is your healthcare decisions. It could be whether or not you go to a doctor or get a surgery, or have to go to a nursing home, or any major healthcare decisions. Then a financial power of attorney is when you've named someone else to make your financial decisions for you, and to maybe pay your bills or call the insurance company, deal with financial matters. At our office, we typically combine the 2 documents into one. So if you're going to choose the same person to be your healthcare decision maker versus your financial decision maker, you might as well just have one document. It's one less thing to lose. It's one less thing to keep track of. If you have 2 different people, for example, maybe you have a daughter that's a nurse and another daughter that's an accountant, then maybe you want to make the nurse responsible for your healthcare decisions and the accountant responsible for your financial decisions. In that case, you would want to divide them up into 2 separate documents. Another important piece is that these are only effective during the lifetime of the principal. So as soon as you pass away, your power of attorney is no longer valid. There are a couple of things, which I think we'll talk about in just a second, that a couple of last decisions that can be made after death, but mostly once you pass away, it's no longer valid. And that's important as we get into talking about the other estate planning documents later, because you need to have something that says what you want after death. Let's see. There we go. Okay, some important points, again, about powers of attorney. For your agent, I know I already said this, but choose someone that you trust because they will have access to your financial accounts. I don't think that we talked about this in the intro, but the Elder Rights Project that I'm the statewide director of, that project is actually elder abuse. And so I see a lot of people who have chosen powers of attorney, agents to be their power of attorney, who have misused that trust. And so, it's just really important that you're choosing someone that you don't think is going to have any issues acting in your best interests. I had a lady one time who she was really debating, the only person she had was her son, and she had another child who lived kind of far away, but her son lived in town, but he had a criminal history for, I think, writing bad checks or something check related, fraudulently check related. And, I really had to have a talk with her. It's probably not the best idea for you to choose him to be your agent because he's going to have access to all of your funds. And if he already has a history of misusing other people's money, you would kind of just be handing it over to him. So there are consequences, and we're going to talk about that. But that's just really important. And as I advocate for people who have been victims of elder abuse, while you have the ability to make these decisions, please make them wisely. Record keeping. The statutes actually require that money not be commingled and that the agent keeps records and receipts of what they do on your behalf. So if it's a husband and wife, if you name your husband your power of attorney, I'm not going to say you can't commingle money because husbands and wives have joint accounts all the time. But it would really not be ideal to have a child's name on a bank account if they are your power of attorney. And we're going to talk later about how you can make it so that they will be able to collect the money in your account after you die. We'll get to that. So, but keep this in mind. And if you already have a child on your bank account, take this time to consider if you really want to keep it that way. My recommendation is that if you make them a power of attorney, they will have all of the access to pay your bills and deposit funds and withdraw funds and do what they need to do on your behalf without being a joint owner on your account. And that's what happens. As soon as you put them on your bank account, they are a joint owner and they have just as much access to those funds as you do. It's also important to note that your agent has a fiduciary duty to act in your best interests. So whoever you choose has a legal fiduciary duty to put your needs above theirs. Self-dealing is one thing that it's a prime example of breaching a fiduciary duty. And I'm going to explain a situation that I've seen in real life. I had a lady one time who her family had moved her to another state to take care of her. And her power of attorney, her agent, was left here in Kansas City and was supposed to be taking care of the house, and which was empty at that point, and managing all the financial affairs. Well, what she did was let her son move into that house for rent-free. And I think there was a really good argument that is self-dealing because she was putting her own and her son's financial interests above her relatives because she didn't rent it out. She could have been renting that property out. In that situation, I would argue that the agent had breached their fiduciary duty because they weren't putting my client's interests above that of her family members. The next important thing to note is that there's a criminal statute. It went into effect first in 2014 that makes a violation of the Durable Power of Attorney Act a criminal act. So this new statute number, it's not so new anymore, but it's KSA 215417, and it's about the mistreatment of an elder person. An elder person is defined as anybody 60 years old or older. And if there has been a violation of the Durable Power of Attorney Act, which includes all of the financial dealings on a power of attorney, then actually the person who breached that duty, who violated the power of attorney and misused it, can be criminally prosecuted. And I will tell you, Johnson County, they have been at the forefront, and I've seen them prosecute quite a few people under this KSA 215417. So also, if you are acting as someone else's agent, say you're acting as your parent's agent, another really important piece is that you sign like this. And there could be a couple of variations on this, but this is the simplest way to teach you. It would be your name, comma, POA for whoever you're acting on behalf of. So John Doe, comma, POA for Jane Doe. When you do this, you are designating that you're signing a contract, not as yourself, but as Jane would otherwise. You're stepping into Jane's shoes. This is important as we get to the next point, because an agent is not personally liable for your affairs or your debts. So some of my clients, most of my clients are pretty low income, and they worry because they have a lot of credit card debt, and they think, okay, well, if I name my child as my power of attorney, then won't they have to be responsible for paying off those credit cards? No, absolutely not. That's not how that works. They have a duty to use your funds in your best interests to, if there's money left over at the end of the month to pay off a credit card, great. If not, they're going to be focused on paying for your food and your medicine and your housing. But they're not personally responsible with their own funds to pay those bills that your income doesn't cover. Now we're going to go back to this signature. That's why it's so important that when you're acting on someone's behalf that you sign this way. Jane Doe, comma, John Doe, comma, POA for Jane Doe. Another example, and I will do this throughout, I'll give you guys examples of things that I've seen in practice before. I had a gentleman he was elderly himself, and he had a very elderly mother, and he had signed the nursing home admission paperwork, but only signed his name, even though he was power of attorney. And that nursing home was trying to get him to pay the bill. And they were making the argument that he signed in his own capacity and that he was liable on the contract. So that's why this is so important. Okay. Next slide. Did everybody see it change? I hope so. Okay. There are a few things that your agent cannot do on your behalf. First would be to make, publish, declare, amend, or revoke a will or trust. So when you're talking about making a will or a trust, you are naming your beneficiaries, who should get what when you pass away. And your agent in your power of attorney has a conflict with that. That would be self-dealing. So they're not allowed to do that. And the statute makes that very clear. So if don't think that if you become your mom's power of attorney, that you can then go and sign a will, putting everything, giving yourself everything. You can't do that. You can also not make, execute, modify, or revoke a living will declaration, or execute or revoke a do not resuscitate order. So essentially, we'll talk about living wills in just a second, but someone else cannot revoke a living will, which is a document that's your decision to basically remove life support, to not be kept alive in a terminal condition. Also, no one can require you against your will to take any action or refrain from taking any action. And they can also not carry out any actions that you have specifically forbidden while you were the principal. That was not under a disability or incapacity. So there are some legal protections under this statute. Okay, there is some brand new power of attorney law that I need to share with you. And this is the first time I've ever presented on this piece of it before. So bear with me as we weave through here. The statute has just been changed as of January 1st of this year. And I've listed the two statutes that changed and that were amended. Essentially, what was happening was a power of attorney document would be drafted, and then that would be taken to a bank, and the bank would review it, and they would say, oh, I don't think this qualifies. We don't want to rely on this. You need to sign this new document of ours saying you give permission. Well, what happens when the power of attorney was drafted 10 years ago and now the principal has dementia and can't sign a new document? This was becoming a problem over and over again. Banks weren't accepting, third parties weren't accepting valid powers of attorney. So the powers that be in Topeka created some new law, and there is now a form for a durable power of attorney, and any new durable power of attorney must be substantially compliant with this form, which I have put a link to here. And also it includes a certification signed by the agent. In my office, we've always had the agent sign a certification, but that's kind of a new thing for some people. And what this certification is it's a signature by the agent that says, I understand I have to keep records and receipts of what I do on this person's behalf, and that I have a fiduciary duty to act in their best interests. A little more than that, but that's a general summary. So if in compliance with this statute, if you've got these two things, a power of attorney form that is substantially compliant with the one on the Kansas Judicial Council that I've listed above, and a certification signed by the agent, then what this means is that a third person refusing to accept a power of attorney in violation of this section could be subject to a court order mandating acceptance of a power of attorney. And this would include reasonable attorney's fees and costs that could be awarded in any action proceeding confirming the validity of a power of attorney if the court determines that the third person did not act in good faith. So it's basically making it so that banks and other third parties have to accept these documents. Now, as we move on, I want to give you a general caution, because you probably all just saw a form and you're like, oh, I've got to go grab that form. I just want to give a general warning that I do recommend that you either see Kansas Legal Services or a private attorney to draft your general durable power of attorney to ensure that it's in line with your own wishes, because this is a very standard form. And as we talked about in the very beginning, there are different types of power of attorney. There's a springing power of attorney versus one that goes into effect right away. Depending on what your wishes are, this may not cut it. I also want to use this opportunity to recommend that of all the documents I'm talking about today, please, 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 please do not go to Office Max or Office Depot or LegalZoom to find these forms online. There's just, every state has different laws. Kansas has different laws than Missouri. So a document that's valid in Kansas might not be valid in Missouri. There are so many intricacies to this. We do go to law school for 3 years for a reason. So, and Kansas Legal Services, which I will talk about at the end, we do offer free legal services to people 60 or over. So just keep that in mind, and be cautious of doing things on your own, even though I did provide the link to the form there. Okay, I'm going to take a sip of water real fast. Okay, a living will. A living will is a document that states if you have a terminal condition that you do not want life-sustaining treatment. That does not include palliative care or comfort care, which can still be provided. Also, you can revoke your living will at any time, even orally. So I'm going to give an example of this. You have stage 4 cancer and you slip into a coma. 2 doctors have stated that you are terminal. If you have a living will, then life-sustaining treatment would not be provided to you, okay? It's the situation where you're already terminal. The next document we're going to talk about, oh, sorry, I jumped too far ahead. Let's go back to the power of attorney and talk about how a living will and a power of attorney interacts. If you have a living will, your agent in your power of attorney cannot legally revoke it. Your agent is not legally allowed to keep you alive, okay? If you do not have a living will, the doctors may very well look to your agent to make a decision about whether or not to keep you alive if you have a terminal condition. So if you absolutely under no circumstances want to be kept alive in that situation, the best thing that you can do is to sign a living will. I guess I will just say that I think doctors sometimes are afraid of being sued. And so if there's a real aggressive family member that is really resistant to invoking that living will, I can't say for sure what the doctor's going to do. But I think that if you don't want to be kept alive, that's your best legal option. Also, make sure you talk to your relatives and your agents and that they know what your wishes are. Because if you haven't had that conversation, somebody may think, oh, mom wouldn't want this, or maybe somebody would think mom would want us to do everything possible. And then you're kept in a situation that you wouldn't have wanted to be in. So make sure everybody's on the same page. Okay, do not resuscitate. A do not resuscitate, a DNR, is a document that states that even if you do not have a terminal condition, that you do not want any life-sustaining measures or life-saving measures. So the example here is that, say you're having a knee surgery, and due to the anesthesia, you code on the table. With a DNR, you would not be resuscitated. So my office does not draft DNRs. Those are, in my opinion, to be filled out with your doctor. They require a doctor's signature. Just make sure you understand. I think it's best to sign one of those if you're at the very end. You are 98 years old. You've lived a long and happy life, and you have a history of strokes or something like that. That's when a DNR, in my opinion, would be probably the best. I have some people who are adamant they would get a tattoo if they could, if that would be legally valid, that they want it to happen sooner rather than later. But just it's a little scary. I mean, to think that you could go in for a surgery and just have some fluke happen and they wouldn't resuscitate you. Okay, now we're going to talk about wills. So a will, a last will and testament, is a document in which you express your intent of who gets what of your property when you pass away and what your final burial wishes are. You can specifically disinherit children or others that you do not want to inherit your property. And you wouldn't believe how often that happens. You also can include a no contest provision, which states if anyone contests this will, that they are automatically disinherited. So things can get dicey when it comes to the end and who gets what property, and this is your control over this situation. If you only have a will, your property must be probated. And let me go back a little bit. Probate court, there are different divisions of court. There's criminal court, there's civil court, and there's probate court. And probate court is where you go when there is an estate and someone has passed away and they're dividing up their property. There are a couple of other things you do in probate court, but that's in general what it is. And so the court oversees the division. If there is a will, then great, that will is filed with the probate court, and then the court distributes the will or the executor does, according to your wishes with court oversight. With that, there are court costs, attorney's fees, and time associated with probate court. If a family is fighting over a matter in probate, it can take years to resolve it. So a lot of people come to us at Kansas Legal Services wanting to know, I don't want to go to probate. How do I avoid probate court? There are several ways. The first that I'm going to talk about is a trust, and we get lots of questions about that. A trust is a legal document that transfers the current ownership of all of your property from you to your trust. So you no longer own your house. You no longer own your car. Your trust owns those things. And by doing that, then it avoids probate court. There are also some tax benefits to that. I'm not going to pretend I know much about tax law, so don't ask me a complicated tax question because I won't be able to answer it. Our clients are typically those that don't have enough funds to have a trust. But there are tax benefits to having a trust. Another thing that's good about a trust is that you can put qualifications on an inheritance. So for example, you can say that someone cannot inherit all of the money in the trust until they turn 35 years old, or whatever age old you want it to be. Or you could get really tricky and say, you know, they have to complete a drug rehab program, and they have to do X, Y, and Z before they can get the benefits of this trust. In my opinion, these are best for individuals who are either millionaires or who have a special needs child. So if you have enough money that you're a millionaire and you're going to get the tax benefits from it, then maybe you do want to get a trust set up, and you're going to go to a private attorney for that, and they're going to charge you an arm and a leg, but you can afford it because you're a millionaire. Or I've seen this too. If there's a special needs child, I had some sisters come see me one time, and they were both disabled, and their mother they were adults at this point. In fact, I think they were seniors, but their mother had thought far enough in advance to have created a special needs trust for them so that they got to live in this house and didn't have to worry. They could still receive all of their benefits and have this house forever. So that's a good reason for a special needs trust. It is expensive to have a trust drafted by a private attorney. Let's see. Oh, okay. Everybody should see now transfer on death deed. A transfer on death deed is a document where you transfer ownership of your real estate to one or more beneficiaries upon your death. This is also an alternative to probate court. So you can do this in lieu of a will, or even in addition to a will. And if you do this in addition to a will, this takes precedence over what the will says. One key thing is that it must be recorded with the county register of deeds office. And I wonder about this sometimes too. We sign all of our documents with our clients, and we get everything notarized, and we tell them explicitly, you have to take this to the register of deeds office. And we send them a follow-up letter reminding them that they have to take it to the register of deeds office. And I'm not sure that it always happens, but if you don't turn it in to the register of deeds office, it is as if it does not exist. So if it is not filed before you pass away, it's as if you didn't sign it. You know, somebody could show up at court, probate court or whatever, and later and say, oh, look, I have this transfer on death deed. Well, was it recorded? Doesn't look like it. Too bad. Sorry, you don't get the house. So that's really, really essential, is that it gets recorded. So the process for this is that your death certificate would be given to the register of deeds office before the property would be transferred to your name, or to the name of whoever the beneficiary is. Also, it becomes null and void if you sell your real estate before your death. So it's a great document to have, and it doesn't hurt anything. So suppose I have a transfer on death deed now, and 2 years from now I sell my house. Then what I'm going to do if I buy another house is I'm going to do a new transfer on death deed. And it just as if it's not like it passes with the person, it passes with the piece of real estate. Again, it only covers real estate. So this is not an all-encompassing solution. It only covers real estate, not cars, not personal property, not bank accounts. But we'll talk about what you can do with those things. Okay, a quitclaim deed. I'm kind of including this just so that you don't do it, but I wanted to let you know about it. A quitclaim deed is a deed that releases a person's interest in a property without stating the nature of the person's interests or rights, and with no warranties of that person's interests or rights in the property. It does not warrant good title like a warranty deed does. So again, legalese. This is kind of a quick and dirty way to sell a house, but not go through realtors, or to give a house to someone. It entirely gives away your interest in the property. So 100%, you no longer own your property if you sign a quitclaim deed to someone else. I just want to warn you all, before you sign one of these, please, please, please consult with an attorney. And if a relative asks you to sign one, you should be skeptical. Signing one can also disqualify you from receiving Medicaid. So I could give a 2-hour presentation on Medicaid any day. I mean, I can't go into it all right now, but basically Medicaid is when you're looking, you run out of funds and you need to go into a nursing home and you don't have any other way to pay for it. You have to apply for Medicaid, which is a benefit for low-income people. And if within 5 years of applying for Medicaid, excuse me, you have given away money or property, then you are disqualified from receiving Medicaid for a period of time based on the value of the gift given. And that's a really scary thing. If you have no other way to pay, you've given your house to your kids, and now they're like, oh, sorry, Mom, I don't know what to tell you. I'm not giving it back. I have one case right now, since I do this elder abuse work. It's in a different county, but I had a granddaughter convince her grandma. In fact, she didn't even tell her what she was signing. She just said, here, sign this. And there was a notary there. The grandma thought she was signing a contract related to a lease. And come to find out, it was a quitclaim deed. And now my client no longer owns her house. So you really have to be careful with these. Also, as far as real estate goes, like I said, it doesn't warrant good title to property. So if you're trying to make sure that you have clean title to the property, a warranty deed through a realtor is always going to be the best way to go. Okay. More alternatives to probate: CDs, stocks, and life insurance. First thing, make a list of all of these accounts so that your family can easily find them. If you haven't done that, if you haven't had the big discussion about where our important papers are, now is the time to do it. And we've talked about COVID and things have become a little scarier and a little more urgent lately. So this is the time to have these conversations with your family members. Write down where your accounts are so that if something happens to you, they know where to contact. They know who to send a death certificate to and who to let know that you've passed away. But you yourself, if you're trying to set up a alternative to probate here, you contact each company that you have any one of these types of assets with. And then there will be a beneficiary form for each of those. And that will avoid probate. So on your life insurance, I mean, that's pretty standard, right? Your life insurance, you fill out a beneficiary form and you can name names of people who you want to get the life insurance proceeds. That's different than probate court. So that's going to take precedence over what happens in probate, unless you have listed the beneficiary as your probate estate, which sometimes can happen. Okay. Vehicles. Go to the Department of Motor Vehicles with your car title. And a lot of car titles now are electronic, so you might not actually have your own car title, but if you do, take it there. And you can ask to add a beneficiary to your car title. There is a form for that, and it avoids probate. This is one of the easiest things that you can do to save your family tremendous hassle. So vehicles are titled pieces of property. And if you haven't done this, your family cannot sell a vehicle after you pass away. They might not even be able to properly junk it. So doing this saves a lot of headaches. And when I'm talking about all of these things, I'm not talking about adding them as an owner or transferring the property to them. These are all ways to add beneficiaries. Okay, so you wouldn't have to give up ownership. Bank accounts. This one's also very easy. Make a list of accounts for relatives to easily find. Make sure that you take all of your beneficiaries' social security numbers with you. When you go fill out a POD, pay on death form at a bank, they will ask for their social security numbers. Tell your banker that you want to add PODs to your account, and do this for each and every account, even if you have different accounts at different banks or different accounts at the same bank. Each account needs to have its own POD form completed. This does not make anyone else a joint owner. It gives them no financial current interest in this bank account. It's only upon death. And it avoids probate court as well. So you could say in your will that your money is to be divided 3 ways among your 3 children. And I've seen this happen a lot. People want to do this a lot, where they name, with the will, they name one of the children as the executor of the will, who's going to come in and divvy it all up. And then they go to the bank, and to make things easier, they only put the executor's name as a POD. Well, guess what? When you do that, that executor doesn't have a legal duty to share with the other 2 siblings, because he or she was named as the only beneficiary on the POD, which takes precedence over what the will says. So you really have to be careful and consistent. If you want your children to share each account equally, then list all 3 of them as POD beneficiaries. Another thing that you could do, and I've seen clients do, if they have different accounts that have similar amounts of money in them, name one child a beneficiary on one account and another child a beneficiary on the other account. So the main point of this is there's a difference between being a joint owner and a beneficiary. And everything that I've told you about tonight before this, as we're talking about alternatives to probate, I was suggesting that you're making people beneficiaries. I only recommend that you have joint ownership of property for married couples. So adding your children to house titles, to car titles, to bank accounts, it causes problems. It can cause liability problems. So first and foremost, suppose that you add your child to your bank account, they become a joint owner, and you think, well, they're just going to write the checks, and that way when I die, they're going to get that money. Well, it's not so easy. What if somebody sues them for money and they're a joint owner on your account? Then your account is open to their creditors. So that's really not a good idea. And I'm going to go back for just a second. When we talked about the bank accounts, remember earlier I said we're going to talk about this later with the power of attorney. So my ideal combination for bank accounts is to have a power of attorney document that gives your agent, your children, whoever it is, the ability to make decisions, pay your bills, do all the things they need to do while you're living, but then to also name them or whoever you're wanting as a POD beneficiary, because then they get those funds after death. So it accomplishes everything of having them named as a joint owner on the account without opening you up to the liability of that. Okay. Also, pretty clear, but you're opening yourself up to theft if you list your children or other people on your bank account as a joint owner. I've talked about how I do a lot of elder abuse cases, a lot of elder abuse work. If they're a joint owner, they can take the money, can't be prosecuted for it because it was their money in the first place. Also, we just spent a couple of minutes on this, but Medicaid denials due to disqualifying transfers. So if you've made a gift, even if you've added someone as a joint owner, that is a gift, and it could cause a denial of Medicaid. Okay, I think I went through that a little bit quicker than I intended to, and I apologize. But I will tell you, Kansas Legal Services, we have funds through Area Agency on Aging all over the state. So Johnson County gives us funding. We also get funding from, we have funding from Leavenworth and Wyandotte County. We have East Central Kansas Area Agency on Aging, and all of the counties. There are about 6 counties that are covered through there. So that's the Kansas City office. But all over the whole state, our offices, we have 11 offices, and we get funding from different Area Agency on Aging to assist people 60 or over. And those would be free services. So it doesn't matter how much money you have. We have given legal advice to people who are millionaires before. Probably not going to draft their estate planning documents because they can go to a private attorney and afford that. But we certainly have done a lot of consultations. We also draft all of these documents that I just talked about, except for trusts. We do not draft trusts. And so you can call 1-800-723-6953 and do an application. Or there's a link here. I know you guys were all emailed out this PowerPoint ahead of time. You can do an online application. I will also recommend to you that you can call your local, either your local Area Agency on Aging, or for example, we go to the Matt Ross Community Center once a month. We go to the Roland Park Community Center, and then also to the Area Agency on Aging in Olathe. So you can call those places directly and get appointments. I will warn you, I think that some of these places have wait lists like out to August, because our attorney who goes to those visits is very, very popular. But you can get a lot of these things done for free, and donations are always welcome. But I want to make sure that if you're 60 or over, that you know about this resource, because it's way better to have someone who understands your situation and knows what they're doing and is a licensed Kansas attorney draft these, rather than you fumbling around and finding forms here and there on the internet and not being sure if they're the exact right ones or if you're filling them out properly. So we do provide this service. Obviously, there are also thousands and thousands of other private attorneys who do this as well. But please, seek counsel and guidance as you get your forms done, and do it timely, because you never know when something's going to happen. I think that's the end of my presentation. And Dylan, I'm ready for any questions that there might be.
Alex, would you believe nobody had a single question the whole time?
No, really?
Yeah, you're right. You're right. by the way, everybody, I do see a few cameras on. If you could go ahead and turn your cameras off, I'd really appreciate it. That helps me on the back end when I dump these recordings down into something that you can review after the fact. Which, shameless plug, by the way, youtube.com/Joko Library. You can scrutinize all my hard work there. So yeah, we had a ton of questions. Before we get into those, I'd like to first of all just ask everybody to take a quick moment and use the chat to thank Alex for breezing through a mountain of material in like less than 60 minutes. That was astounding. So thank you so much on everyone's behalf, and I see all the chat messages rolling in. And so yes, my heart is filled. I'm sure yours is too. This is so great. So yeah, real quick, I'll take care of a few more housekeeping things here as we wind down the recorded version of the presentation. Real quick, everybody, our next career in finance program will cover the topic of coping with the stress and anxiety felt during times of occupational crisis or career transition. That program will feature Kansas City's own Women's Employment Network and will take place this next Monday afternoon, 1:30 p.m. on Monday, April 25th. Now, you can visit jocolibrary.org and click on the Career in Finance feature on the homepage to discover upcoming events, sign up for our monthly Career in Finance newsletter, or find additional career in finance resources. Once again, in terms of recordings, not just this one, which will be up fairly shortly. I apologize. It's going to be a couple weeks for me since I'm actually supposed to be on vacation right now. But I will have that posted in early May, FYI. But be sure to check out youtube.com/Joko Library to check out our library of program recordings. They are all there under the Career in Finance playlist. Thank you all once again. I'm going to wrap up the recorded portion of this presentation, and then we're going to get into Q&A. So everybody have a great evening. Everybody who's watching this after the fact, bye-bye. We'll see you next time.